Welcome to the deep dive. Today, we're tackling something that's absolutely crucial for anyone building serious wealth defense. We've gone through a huge stack of material on South African trusts, on entity structuring, and our mission is, well, pretty simple. Turn all that complex strategy into clear, actionable knowledge.
It's so important.
Because for any serious investor or, a business owner in South Africa, the real goal isn't just piling up assets.
Yeah.
It's about safeguarding them. We're talking about building a proper financial and legal fortress around what you've earned.
And that fortress analogy is perfect because asset protection has to be proactive. It has to be structural.
Meaning you build the walls before there's a problem.
Exactly. If you're just relying on something reactive, like insurance, which is essential, don't get me wrong, you're still exposed. Every single policy has limits, it has exclusions, and that's where a strong legal structure comes in.
So that's our mission for this deep dive. We're going to unpack the positive power of South African trusts and these layered structures. And maybe more importantly, understand why you need expert guidance to stop the whole thing from being called a sham by the courts.
Yeah, just to frame this legally for a moment, it's important to know that South Africa, we don't have what you might see in the U.S., like domestic asset protection trusts or DAPTs.
Okay.
Our system is different. Our local inter vivos or living trusts can serve a similar function, but they demand really rigorous compliance and maintenance to be effective. You have to earn the protection.
All right, let's get into it. Let's start with the immediate danger. Why is just owning, say, a rental property or shares in your business in your own personal name, why is that so dangerous?
Because it creates direct total liability. The second an asset is in your personal name, your entire personal world is exposed.
Everything.
Everything. If your business gets hit with a massive lawsuit or a tenant sues you for an injury at a property, that judgment can attack all your personal wealth.
So your home, your savings, your retirement fund, it's all on the table.
There's no firewall at all.
So the whole point of using an entity like a company or a trust is really just to build that firewall. It's a containment strategy.
Precisely. It creates a legal veil. Liability gets confined to the specific entity where the risk actually happened.
So if property A is in company A, a problem there can't touch property B in company B.
Generally, no. It shields company B, and more importantly, it shields you personally.
But let's talk about the big landmine here. The sham risk.
Yeah.
You can't just move your assets into a trust the day you get a letter from a lawyer, right?
Absolutely not. And this is so critical. Timing is everything. The moment a claim is known or even just foreseeable, any transfer you make after that is vulnerable.
How so?
Under the Insolvency Act, creditors can go back and challenge those transfers. They could look back anywhere from 6 months to 2 years, depending on the situation, and have them set aside if they were made to, defraud the creditor.
So if you wait for the storm to hit?
It's already too late. The structure has to be in place, funded, and operating correctly long before any threat appears on the horizon.
We've covered the defense side, the scary stuff. But what about the positive side? Beyond just shielding from lawsuits, why should an investor or a business owner go through all this trouble?
Oh, the benefits go so much further than defense. We're talking about legacy, continuity, and real tax efficiency. I'd say there are probably 5 core pillars.
Okay.
First, as we've said, is the asset protection. If you, the founder, are personally sued, the business shares sitting inside that trust are generally shielded. That's provided you're not also a beneficiary, which is a key structural point.
Right.
Second, and this is massive for business owners, is estate planning and continuity. The trust doesn't die when the founder does. This means you get seamless succession for the business. It completely bypasses the South African probate process.
Which can be a nightmare. I've heard it can freeze assets for, a year? 18 months?
Easily. And during that time, the business can grind to a halt. Plus, you avoid the executor's fees.
Which can be huge. What are they, like a percentage of the whole estate?
Up to 3.5% plus VAT on the gross value. By having the business in a trust, it doesn't form part of your personal estate, so you save the family a huge amount of capital right away.
Okay, that's a massive benefit. What's number 3?
Tax efficiency. This is where the real intelligence of the structure shines. Trusts let you use what's called the conduit principle.
So what does that actually mean?
It means income earned by the trust can be distributed or it can flow through to beneficiaries who are in lower personal income tax brackets.
So instead of the trust paying tax at its maximum rate, which is, 45%?
Exactly. Instead of that, the income goes to, say, your child who is a student and has a very low marginal tax rate. You're using the whole family's tax thresholds efficiently. And, of course, it also minimizes estate duty.
Because the assets aren't in your personal name when you die.
That's right. The fourth benefit is creditor protection for the family. If you as the founder take a big personal risk, like signing a huge personal guarantee for a business loan, and that loan is called up,
The family home is safe.
the family home, the kids' education fund, that can all be protected within the trust. And finally, number 5 is just flexibility. A discretionary trust allows the trustees to adapt to future events, a beneficiary's divorce, a disability, changes in tax laws, without having to go to court.
Okay, that list of benefits sounds almost too good to be true. So what's the trade-off? If it's this powerful, why doesn't every single person with a small business set one up?
That is the critical question. The trade-off is the cost and the ongoing admin. It's the compliance burden. If you don't hold the meetings, keep meticulous records, file the separate tax returns, the whole structure can be deemed a sham. For a really small business, the setup and maintenance costs might not be worth it until you reach a certain level of assets or risk.
Let's make this practical. How does an investor take this theory and build a real-world structure? Let's use real estate since it's such a high liability area.
Okay, so the most basic building block is the liability firewall. We always recommend using a single property FUR LTD.
Meaning one company for each property.
One company per property, or at least for a small cluster of similar properties. So a slip and fall lawsuit at property A, which is in its own FUR LTD, is contained there. It can't contaminate properties B and C.
Simple enough? What about for a bigger portfolio?
For a more robust setup, you use a multi-layered structure. We sometimes call it a structure 4.
4 layers. Okay, break that down for us.
At the very top,
Yeah.
layer 1, you have your discretionary trust. This is the ultimate owner, holding everything for the family's benefit. The trust then owns the shares of a layer 2 entity,
Which is?
usually a holding company. Its only job is to own the shares of the companies below it. It's a clean shell.
Okay, hold on. Why the extra layer? Why doesn't the trust just own the property companies directly?
It's about separation again. The holding company centralizes the ownership, but then it owns the individual layer 3 SPVs, that's special purpose vehicles.
And these are the PUDI LTDs that actually hold the title deeds to the properties.
Exactly. You might have one called Durban Coastal Properties KD Ltd. and another called Godon Commercial PUDI Ltd. A huge risk in Durban doesn't spill over and affect the Gauteng assets.
And what's the 4th layer?
This is the crucial one. Layer 4 is a separate management company. This company handles all the operational risk. It signs the lease agreements, hires the maintenance staff, deals with tenant disputes.
But it owns nothing.
It owns absolutely no valuable real estate. It's asset poor.
That's the real firewall. So if the management company gets sued over an employment issue, the actual properties safe inside their own SPVs, owned by the holding company, owned by the trust, are completely untouchable.
That's the goal. The assets and the liabilities are separated across 4 different legal entities.
Now for the part I find fascinating. The structure itself is useless if you don't maintain it. What are the common devastating mistakes people make that just destroy all this protection?
The courts are so clear on this. When they decide to pierce the corporate veil, they're usually looking for the same few things. The first, and the absolute death knell, is commingling assets.
Using the business account as a personal piggy bank.
Exactly. Paying for your groceries, your kids' school fees, a family holiday straight from the PUDI Ltd account. The moment you do that, a court says, there's no real separation between you and this company, and the whole thing collapses.
What's the second big one?
The sham trust. This is all about failing to run it like a proper trust. Not holding regular documented trustee meetings, not minuting your decisions, not filing formal resolutions for big transactions like buying a property.
So what are they looking for as proof?
They'll scrutinize the trust deed and the minute book. If they see the founders just making all the decisions alone, acting as the only signatory, ignoring the other trustees, they'll say it's just a facade, an alter ego.
So you have to prove there's independent governance.
You must. Every major decision needs a resolution. If the trust makes a loan to a beneficiary, it needs a proper, enforceable loan agreement with repayment terms and a reasonable interest rate. An endless, interest-free loan is a massive red flag.
Okay, and the third fatal flaw.
Undercapitalization. Creating an entity to hold a 10 million rand asset, but only putting 100 rand of capital into it and then sucking all the cash out. Courts can see that as an attempt to create a structure that was never intended to be able to meet its obligations.
So the big takeaway is that compliance is the protection. The shield is only as strong as its maintenance,
It's everything. Meticulous, boring, consistent maintenance.
which is the perfect transition. So the legal structure is the shield. But I guess that makes insurance the armor. Even with the best structure, it's not optional.
Not at all. The structure protects your other assets, but insurance is what pays the bill for the disaster itself. It keeps the entity from going bankrupt from one single claim.
So for a property investor and say, what's the absolute non-negotiable insurance?
Public liability, no question. This is so critical because one serious injury, a slip and fall, or tragically, a child drowning in an unfenced pool, can lead to a multi-million rand judgment. We see them hitting 5 million rand and more.
Wow.
That cover pays for the huge legal defense costs and the final settlement. It saves the entity. We recommend a minimum of 5 million in cover, but honestly, 10 million is safer these days.
And for the building itself, what's the mistake people make with building insurance?
Insuring for market value or what they paid for it instead of replacement value.
What's the difference?
Replacement value is the full cost to demolish the old structure, clear the site, and rebuild it from scratch at today's prices. If your R4 million building is only insured for R2 million, the insurer will apply the average clause.
Meaning they'll only pay half of any claim.
Exactly. They'll only pay 50% of the claim, leaving you massively out of pocket and maybe unable to even rebuild.
What about protecting the income stream?
Two others are vital for a portfolio. Loss of rental income, which covers you if the property is uninhabitable after a fire or flood. And especially in the South African context, rent guarantee or tenant default insurance. This is critical. It can cover months of lost rent during a lengthy eviction and the cost of malicious damage that goes way beyond the deposit.
Okay, so implementing all of this, these multi-layered structures, the paperwork, the ongoing compliance, this is clearly not a weekend DIY project.
Absolutely not. And that is exactly where a specialized trust consultant comes in. Their whole role is to provide expert guidance, but also to manage the entire process, from the initial setup to that critical annual maintenance.
Their mission is to take the legal burden off your shoulders.
Yes, and to educate you on how to maintain that separation we've been talking about so the structure actually works when you need it to.
So who really needs this level of help?
Typically, it's business owners planning their succession, high net worth individuals, parents looking to secure their children's financial future, and really anyone who is actively trying to legally reduce their future estate duty and taxes.
And why a specialist consultant over, say, just a standard accountant?
A good accountant is vital for the tax side, of course, but managing the deep fiduciary duties and the compliance needed to make a trust bulletproof. That requires a real specialization in trust law and asset structuring.
Right.
A trust consultant, someone like Lumka Sturman, specializes in helping South Africans navigate this complex world. They ensure the structure is tailored perfectly to your needs, and they keep you compliant with the law.
So the value they bring isn't just the setup, it's the long-term peace of mind that the fortress you've built will actually stand up if it's ever tested.
Exactly.
Yeah.
It's the assurance that the legal separation is real and that your legacy is protected.
Okay, let's bring this all together then. We've established that combining a sound legal structure, the shield, with robust insurance coverage, the armor, is really the only way to properly safeguard wealth in South Africa.
And the goals are clear. It's wealth preservation across generations, it's seamless continuity for your business, and it's intelligent tax minimization. Those are the pillars of lasting financial security.
And I think the final thought for anyone listening is this. Protection isn't paranoia, it's preparation. If you're building serious wealth, the question really isn't whether you need the structure, but whether you'll get it set up before you need it.
For anyone ready to secure their legacy and navigate the complexities of our trust law, getting expert guidance is paramount. A dedicated trust consultant like Lumka Sturman can simplify this whole process and provide that personalized professional advice to make sure your structure stands strong.
We highly recommend you explore this further. You can visit Lumka Sturman's website, that's www.lumkasturman.com. You can learn more about her services there and even download resources like a checklist to help you avoid these critical pitfalls we've discussed. Until the next deep dive, be prepared and be protected.